Well, hello dragons, and welcome to this instructional video for Lesson 12, Part 1, Interpreting the Bill of Rights. The main idea behind this civics lesson is since the ratification of the Bill of Rights, the amendment's broad descriptions of rights have often required interpretation by the courts. With that in mind, by the end of watching this video, you'll be able to describe the role of the courts in settling disputes over citizens' rights, summarize the Supreme Court's decision in the Tinker case, review both sides of the Skokie case and describe the court's decision, examine how the court has widened the rights of the accused in both the Gideon and Miranda cases, and describe the continuing challenge of citizens in protecting our own rights. Now that the outcomes for this lesson have been shared with you, let's get started. What happens when people disagree about the meaning of our rights under the Constitution? Consider freedom of the press and freedom of speech as examples. Is a school principal violating students' rights when he or she censors an article that was written for the school newspaper? Does a person have the right to make a speech that causes listeners to riot, causing injury to others and damaging public and private property? The rights of citizens are often difficult to interpret. One reason is that the first 10 amendments to the Constitution are broad descriptions of rights. They were not intended to explain how those rights apply to every situation. Another reason is that sometimes certain rights have to be weighed against other rights. For example, suppose a person wants to make a speech that may cause a violent reaction. The right of that person's free speech must be weighed against the importance of providing for the safety of other citizens. The people who tackle the difficult job of interpreting the meaning of citizens' rights are the judges in our nation's courts. As legal experts, they decide whether people's rights are being violated by the actions of other citizens. They also decide whether rights have been violated by any laws. Usually, cases involving citizens' rights are first brought before local judges. If necessary, the decisions of these judges may be examined by higher courts, such as state courts. A few cases that start off in local courts eventually reach the United States Supreme Court. These cases often have far-reaching consequences for the nation. You will now learn about 4 challenging cases that reached the Supreme Court. The first 2 cases involve First Amendment rights. The last 2 involve rights of the accused. The decisions of the court are presented as case studies, which are descriptions of situations or conflicts, the issues involved, and the decisions made. Case studies can help you see principles of the Constitution being put into action. You can see how an ideal, such as freedom of speech, applies to a real situation. As you listen to each case study, picture yourself as one of the 9 justices or judges of the Supreme Court. Think about how you would decide the case. On December 16, 1965, 2 students in Des Moines, Iowa, 13-year-old Mary Beth Tinker and 16-year-old Christopher Eckhart, came to school wearing black armbands. The next day, John Tinker, Mary Beth's 15-year-old brother, also wore a black armband to school. The students were protesting American involvement in the Vietnam War. Their small protest would eventually cause the Supreme Court to wrestle with 2 questions. What is meant by speech and freedom of speech, and what rights do students have under the Constitution? When Des Moines officials first learned of the students' plan to protest, they announced that armbands would be forbidden. When the students wore armbands anyway, they were suspended. The Tinkers' parents argued that the school board was denying the students' right to freedom of speech. They declared that the students had not disrupted classes or had interfered with other students' rights. School officials defended the armband rule, stating that it preserved discipline. They argued that schools were not places for political demonstrations. The case first came before a local court, which ruled that the armband rule was necessary to avoid disruption of classes. After a higher court also affirmed the school district's decision, the students had one last hope: the Supreme Court. The Supreme Court heard the case and ruled in favor of the students. It held that armbands were a form of speech because they were symbols representing ideas. The justices also said that the protest was protected by the First Amendment because it had not interfered with other students' rights to an education. Most importantly, the court emphasized that students do have a basic right to free speech. The court declared, "It can be hardly argued that students or teachers shed their constitutional rights to freedom of speech or expression at the schoolhouse gate. Students in school as well as out of school are persons under the Constitution." Think about the court's ruling. Why is it important for students to have freedom of speech? How should that freedom be limited? What responsibilities go along with it? When may freedom of expression be limited? What other rights must be considered? What if a person or group expresses ideas that are not very popular? All of these questions were involved in the Skokie Case, one of the most controversial in our nation's history. The year was 1938. Members of dictator Adolf Hitler's Nazi Party attacked the homes of Jews throughout Germany. Between 1938 and 1945, the Nazis forced millions of Jews and other people into camps to be starved, tortured, and killed. The year was 1977. The place was Skokie, Illinois. The town's residents included 40,000 Jews. Many of these people had survived the horror of Nazi camps, but many of their relatives had not. In May, a small group of uniformed men applied for a permit to march through Skokie. Each man's uniform displayed a large black swastika, the symbol of the Nazi Party. Shocked and enraged by the plans of these members of this Nazi group, Skokie officials wanted to prevent the march. They informed the Nazi group that it would have to obtain $350,000 of insurance before a permit to march would be issued. Town officials hoped that the cost of this insurance would dissuade the Nazis from wanting to march in Skokie. When the Nazis planned a rally to protest the insurance requirement, the county court stated that the group could not hold a demonstration. The court forbade anyone to march in a Nazi uniform, display the swastika, or distribute material promoting hatred. A long and painful court battle began. From the Illinois courts to the United States Supreme Court, judges faced a challenging question. Does the First Amendment protect even Nazis in their message of hatred? The case stirred nationwide interest. Many people argued that the First Amendment does not protect people who want to destroy freedom and spread violence. As one citizen stated, freedom of expression has no meaning when it defends those who would end this right for others. Another said, in Germany they also started with a bunch of crazies. Anyone who advances killing should not be allowed to rally. Those who argued that Nazis do have a right to freedom of expression included members of the American Civil Liberties Union, or ACLU, an organization devoted to defending citizens' rights under the First Amendment. ACLU lawyers asked a basic question. If the government can deny freedom of expression to one group, what will prevent it from denying that right to any other group? A Jewish member of the ACLU summed up his argument by saying, "The First Amendment has to be for everyone, or it will be for no one." Clearly, the Skokie case presented a major challenge for the courts. There were powerful arguments and strong feelings on both sides. Because they were unwilling to accept the county court order, the Nazis took their case to the Illinois Supreme Court. However, that court refused to overrule the county court or to rule on the fairness of the Skokie laws. Therefore, the Nazis asked the United States Supreme Court to hear their case. On the day I was born, June 14, 1977, the Supreme Court ordered Illinois to hold a hearing on their ruling against the Nazis. The court did not discuss either the county court order or the Skokie laws, but its decision led the Illinois and U.S. District Courts to examine those laws closely in light of the First Amendment. For almost a year, the Illinois and U.S. District Courts struggled with the issue of limits on the Nazis' right to freedom of expression. The courts finally decided that the Skokie law requiring insurance violated the First Amendment. The court stated that the insurance was too costly for most groups and therefore limited free speech and assembly. Also, the law had not been applied equally. The town officials required the Nazis to pay for insurance, but other groups were allowed to hold rallies without insurance. The courts also concluded that the Nazis had a right to distribute material expressing hatred. The First Amendment protects the expression of all ideas, even beliefs that threaten the basic principles of our nation. As Justice Oliver Wendell Holmes said over 50 years before the Skokie case, our Constitution protects the principle of free thought, not free thought for those who agree with us, but freedom for the thought that we hate. The courts discussed whether the Nazi uniform and swastika symbol were protected by the First Amendment. Earlier court decisions, particularly the Tinker case, had established that symbols were a form of speech. The issue was whether the hated swastika would cause a violent reaction, threatening public safety. By planning to wear their swastikas in Skokie, were the Nazis guilty of trying to start a fight? The courts heard strong testimony from Jews in Skokie about the meaning of the swastika to them. One concentration camp survivor angrily declared, "I do not know if I could control myself if I saw the swastika in a parade." Skokie attorneys argued that for Jews, seeing the swastika was just like being physically attacked. The Illinois Supreme Court deeply sympathized with the Skokie residents, but decided that the swastika could not be banned. Otherwise, the mere possibility of violence could be used to keep anyone from exercising the right to freedom of expression. The court reluctantly concluded that the Nazis could wear their symbol, just as war protesters could wear black armbands. The United States Supreme Court let the Illinois court's decision stand, thereby removing the last roadblock to the Nazi rally. In the summer of 1978, the Nazis finally held 2 rallies, but not in Skokie. Both rallies were in Chicago, and the Nazis faced thousands of people demonstrating against them. A heavy guard of Chicago police officers was assigned to prevent any violence. The Skokie case showed that the First Amendment protects not only views that most citizens support, but also unpopular beliefs. The First Amendment makes possible what Justice Holmes called a marketplace of ideas, in which all views may be expressed. Holmes believed that people should be allowed to hear many different ideas. Then they can accept or buy the good ones and reject the bad. According to Justice Holmes, the test of a good idea is the power of the thought to get itself accepted in the competition of the market. What do you think? Should any person be allowed to state his or her beliefs, even when those beliefs are very unpopular or encourage hatred and prejudice? On June 3, 1961, in Panama City, Florida, Clarence Gideon was charged with breaking and entering a pool hall. When brought to trial in a Florida court, he pleaded not guilty. However, he could not afford a lawyer, and the court refused to provide him with one. The court said Florida law permitted court-appointed counsel only for capital offenses where the defendant could be executed. He was found guilty and sentenced to 5 years in prison in the following trial. Clarence Gideon was determined to prove that his rights had been violated. As he later wrote, "I always believed that the main reason of a trial was to reach the truth. My trial was far from the truth." Gideon spent hours in the prison library studying law books. He read that the right to have a lawyer is stated in the Sixth Amendment. However, books about previous cases revealed disagreement over whether the right applied to state courts. Believing that it should apply to any court, Gideon wrote a letter asking the Supreme Court to hear his case. The issue of whether state courts should provide lawyers to represent the poor had already become before the Supreme Court several times. The court had ruled that this right to a lawyer applies only to special circumstances. Gideon's situation did not seem special, but the Supreme Court agreed to re-examine the issue. When the case came before the court on January 14, 1963, all of the justices concluded that no court should deny a citizen the right to have a lawyer because he or she is too poor to afford one. It was a victory not only for Gideon, but also for thousands of other Americans who would now be guaranteed the right to have a lawyer if they were ever accused of a crime. In winning his case before the court, Gideon also won the right to a new trial in Florida. This time, the court paid for a lawyer to represent him, and he was found not guilty. In learning about his rights and taking action to defend them, Gideon stands as an example that every citizen's voice can be heard. On March 13, 1963, in Phoenix, Arizona, Ernesto Miranda was placed under arrest and taken to the police station, where he was questioned regarding a kidnapping and sexual assault. After several hours of police interrogation, Miranda confessed to the crimes, signing a document saying he had full knowledge of his legal rights. In the ensuing trial, Miranda's confession was used as the main piece of evidence to convict him. When the jury returned a verdict, it found Miranda guilty, and he was sentenced to 20 years in prison. Miranda appealed the verdict to the Arizona Supreme Court, claiming that his confession was not provided voluntarily, and he was unaware of his right to have an attorney present during the questioning. When the Supreme Court of Arizona ruled, they upheld the trial court's decision, ruling that Miranda's constitutional rights were not violated because he had not specifically requested a lawyer before police began questioning him. Miranda then appealed that Supreme Court ruling to the United States Supreme Court. Miranda argued that his Fifth Amendment right against self-incrimination and his Sixth Amendment right to an attorney were violated. Upon hearing the arguments of the case, the Supreme Court ruled that defendants must be made aware of their rights to remain silent, that anything they say can and will be used against them in a court of law, and that they have the right to an attorney present during police questioning. Following Miranda v. Arizona, he received a new trial without his confession being admitted as evidence. However, Miranda was still found guilty based on other evidence, specifically witness testimony, and he was again sentenced to 20 years in prison. Protecting the rights of citizens is not just the responsibility of judges and laws. It is a continuing challenge that we all share. Another famous American judge, Learned Hand, made this point in the following way. I often wonder whether we do not rest our hopes too much upon constitutions, upon laws, and upon courts. These are false hopes. Liberty lies in the hearts of men and women. When it dies there, no constitution, no law, no court can even do much to help it. While it lies there, it needs no constitution, no law, no court to save it. As Judge Hand emphasizes, the rights of American citizens are not protected just because they have been written down in our nation's Constitution. We as citizens of the United States, even while still students, play a key role in protecting our rights. By respecting each other's rights, we help guarantee that the Bill of Rights survives, not just as dry ink on faded parchment, but as beliefs that we Americans live by. So that's the way it is with Lesson 12, Part 1, Interpreting the Bill of Rights. By this point, you should know that most cases are resolved in local and state courts. The Supreme Court rules on a small fraction of cases, but the decision it makes on those cases affects many people who are not part of the case. The Tinker case guaranteed the First Amendment applies to students. The Skokie case extended the First Amendment to unpopular ideas and beliefs. And both Gideon and Miranda have guaranteed rights to those accused of crimes. Don't forget to subscribe to my channel to have the entire catalog of civics videos available at your fingertips. Click the subscribe button, then click the follow bell to receive notifications as to when the channel is updated. Thanks for watching, and I'll catch you in class, dragons. See ya!